These 26 civil servants who serve their country so much that they sue them are now trying to get Elon to get out of the government. They say, what? Elon Musk is not an officer. USAID officials either took and ratified these contract actions. When you see that, you're like, uh-oh, that's a legal phrase. If you think something is bad happening, we'll see it. Victory for Elon and DOGE. A nice appeal coming out of the Fourth Circuit. Starting to see some of these higher level courts clean some of the garbage up from the lower level district judges. This was the J. Doe's case brought by Norm Eisen and his hack organization against Elon. These 26 civil servants who serve their country so much that they sue them are now trying to get Elon to get out of the government. And this was battled down in the lower courts, now coming out of the Fourth Circuit Court of Appeals. And it's a nice victory for Elon and Trump and DOGE and America. But the ultimate verdict is that the lower level preliminary injunction, okay, so the lower level judge stopped Elon and DOGE. Now it is going to be stayed, right? So the lower level judge's decision is stopped for now. So they can continue to do what they're doing. This is generally the beginning of the end for them. Here's what it says. All right, Elon Musk, writes the Court of Appeals, Elon Musk and DOGE have moved to stay the lower level court's preliminary injunction pending their appeal, and finding that they are going to win, or made a strong showing at least that they're going to win, and that they're going to be injured if we don't stop this, and that the other people, the J. Does, are not going to be injured, we grant their motion. Nice victory. Now, this matter involves USAID. Trump executive order nuked it. 26 unidentified current and former employees who are such babies they can't even sue under their own names sued, saying you can't cancel our contracts. They placed USAID on personal leave, said you got to hire us back. They said you can't close our headquarters, open it back up, put the sign back up. They claimed that this was a violation of the appointments clause, right? It wasn't. Their contracts were canceled, and they said, no, Elon's operating outside the law. Additionally, they claimed that his actions, Elon's, in dismantling DOGE are infringing upon Congress and more. And for those wrongs, they seek a judicial declaration. They say they want you, court, to come out and say Elon is violating the Constitution, and everything that Elon and DOGE has done has been unlawful and should undo it all. And the lower court judge agreed, because they're nuts. Now, they disagree at the government, Trump. They say, what? Elon Musk is not an officer. He is a senior advisor. He doesn't have the authority to do anything. There is no actual or effective authority at all. In fact, that person who runs DOGE is called Amy Gleason. And other people are actually taking the decisions. For example, Rubio and Pete Morocco at the State Department with USAID. So then Norm Eisen's J. Doe's babies plaintiff, they moved for a preliminary injunction, and the lower court granted it, finding that Trump violated the Constitution. Oh no, the district court said reinstate everything. Okay, we read this. Reinstate everything. Make them contractors again. Give them their emails back. Let them take their, however long breaks and all the things. So then they moved for clarification, and they also said that Lewin, right? Lewin was the guy who was in charge of DOGE. District court came back out and said, yeah, sorry, Lewin has to be prohibited as well. He cannot be in charge of the agency. So the court came back down and said, listen, here's what we got to talk about. Are you going to win or not? Is there a likelihood of success? Is there irreparable injury? Is there going to be a substantial injury? And where is the public interest? And they say Trump's going to win on this. I mean, listen, here's the factor. They say, to start here, we got to talk about the defendants. Trump. They've made a strong showing that the lower level court made a mistake and erred, saying that the other people were going to win. The ultimate question in those two claims are, did the actions violate the Constitution? Now, the district court, the lower court judge, found that the defendants established that most actions were approved by Rubio. Okay, they're not Elon's actions. It's Rubio, it's Morocco, it's other officials. And for those reasons, the district court conceded, he even admitted, that the termination of the contracts, the administrative leave decisions, and the other reductions in force, he admits they were approved or ratified by USAID. He wrote it in his opinion. He said, plaintiffs have not provided specific evidence refuting Trump's documentation. So it's like, okay, well, they've got it in order. It says this guy approved it, signed it, signed signature here, that he had power to do it. Okay. He said, the judge, that is, at minimum, more likely than not, USAID officials either took and ratified these contract actions, right? The judge, more likely than not. When you see that, you're like, uh-oh, that's a legal phrase. So we're talking about an evidentiary standard here, and they met it. It's a preponderance of the evidence, more likely than not, 51% 1%. It's more likely that they did it. They haven't refuted it. So if all things are equal, I got to give the benefit to the government that they had the power to do it. He admitted it, wrote it. Thus, as the district court acknowledged, those actions provided no basis for the injunction. So why'd you do that, Judge, if you even admitted it and wrote it in your opinion? So the district court concluded, however, despite all that, Trump produced no specific evidence showing that they approved or ratified the decision on the headquarters or on the website. So then he granted an injunction based on those two actions. He's like, well, I didn't see any paperwork with the headquarters. I didn't see any paperwork with the website. So since that, I'm in charge. And now you're all prohibited from shutting it down. He says, this is ridiculous. That conclusion is dubious. Obviously, judges, says this is the judge writing, but talking to the lower level judge. The only evidence cited by Norm Eisen's DOGE in support of their motion, which was relied upon, were social media posts and news reports. To be sure, Musk claimed involvement in USAID decisions. He did, but that's not the point. No one disputes his involvement. We all know that. The question is whether Musk directed those decisions and did so without the approval or the ratification of someone with power. And no record evidence shows that he did, because he didn't. In contrast, Trump put forth evidence that all pertinent actions, Musk acted as a senior advisor. He was not acting as the administrator of DOGE. They got paperwork. All decisions pertaining to USAID were made by those who were authorized to do it. And also, the relocation of Customs and Border Patrol into their headquarters occurred after Rubio and Morocco had assumed their roles. So they made the decisions to kick them out of their building. So finally, the news articles and social media posts don't indicate that Rubio and Morocco were not a part of those decisions. Actually, the posts that you guys reference say that they were involved. And as to Musk, the evidence before us creates a strong likelihood that he functioned as an advisor, carrying out the president's policies of shrinking government and reducing spending. Advisor, not an officer. Officers require constitutional appointment. But the current evidence in the record indicates that Musk's actions did not involve the exercise of authority of an office granted by the law, but rather the implementation of the policies. In order to be an officer, the law says this, he must be exercising significant authority pursuant to the laws of the United States. He must be occupying a position established by law. Based on the record, he's not. He doesn't satisfy either one of those criterion. And further, regardless of whether the alleged actions authorized, ratified, or not, regardless, whether those could form the basis of a separation of powers claim that the executive branch is dismantling USAID in contravention of Congress, they have failed to name the unconstitutional actors as defendants. The district court identified USAID, in other words, they pleaded this case wrong, like they filed this lawsuit wrong. The district court identified USAID as authorizing and ratifying all actions complained of, except closing the prior headquarters and taking down the website. Yet neither the executive nor USAID is even named here. Confined to the two allegedly unlawful actions identified by the district court, there is no strong likelihood of success on the merits of a separation of powers claim against a defendant who the district court found to be acting without authority and who the government claims is not an officer of the United States. That's very smart, right? They're saying, wait a minute, the district court says Elon is operating illegally. He has no power, but this is also a constitutional violation because it's a separation of powers and Elon is taking the power from another branch. But you just said he has no power. So isn't that the claim? Like, you can't parlay a claim. One is necessary and contingent upon the other. So while the role and the actions related to USAID are not conventional, being unconventional does not mean unconstitutional. Hello. Just because Elon is effective and getting things done doesn't mean it's illegal. And none of this is to say that plaintiffs will not be able to develop evidence of unconstitutional conduct as this progresses. If you think something is bad happening, we'll see it. Our holding is merely that at this time, the record does not support the finding of constitutional violations. So even apart from these evidentiary issues, defendants have shown the district court, Trump, that they erroneously concluded that there was harm here. Now, to start, the court correctly noted that these alleged constitutional violations alone, right, we have contract claims and constitutional claims. Now, the judge said, if we only have these constitutional violations alone, that's not irreparable harm. So what we need is individualized irreparable harm. And the district court found it in three ways. Lower level judge said, one, well, John Doe was overseas USAID, and now he's in a high-risk location, and their electricity and cell phone and internet bills aren't going to be paid, and he's going to be in danger. Irreparable harm to him. And he complained about this, saying, we're going to lose access to our systems. Then they went to John Doe 12. He had remarks accusing USAID workers. He heard remarks from other people. And John Doe said that Musk's derogatory remarks about USAID have a direct negative impact where he works. Again, the district court said, so pathetic. Musk's mean comments are irreparable harm to these pathetic John John Does who were so cowardly they can't even sue under their own names. 3, the district court found that their fear that personal and sensitive information could be released created irreparable harm. Not that it was going to be released, but that it could. But other than his concern over a lack of care and a lack of assurances, the record contains no evidence of any disclosure. None of the evidence that was submitted establishes the irreparable harm that's required for an injunction. Our law is clear. The frequently reiterated standard requires irreparable injury that is likely. Here, the district court found this because of their subjective fear, because they're honestly babies themselves. Like not even a reasonable objective fear, a personal subjective fear. Emotional damage, fear that their reputations will be harmed because they're cowards. But subjective fear is remote and speculative. It's insufficient for an injunction. So aside from their fear-based damages, they also allege emotional distress based largely on loss of employment. J. Doe 19 is emotionally and psychologically harmed by defendants' actions. The biggest babies you've ever seen. However, they allege no violations of employment law or any breach of conduct. There are even any physical manifestations of this, like stress eating or something. Like I put on another 100 pounds. I'm up to 5,000 pounds now. Furthermore, to the extent that these alleged harms are cognizable damages at all, most can be remedied by money. Okay, it's not irreparable. Just pay them. It's a contract dispute. So they can just go get their money in another jurisdiction, and they have failed to show any irreparable injury as required under our precedent. Last, for several reasons, defendants Trump have shown that the district court erred when considering the balance of the equities. To begin, mandatory obligations of the order extend well beyond the relief that's even demanded by the people who brought the lawsuit. Injunctions of this scope are disfavored, where they're unnecessary to address the alleged harms. Also, the lower level judge failed to limit the relief to the irreparable harms it found. For example, they want Trump to submit a written agreement indicating that USAID will be able to occupy its headquarters back in DC, saying put them back in their building. But that doesn't even address the harms. Like John Doe, they're stress eating every day. They're going to be just stress eating back in there because how's that going to fix their emotional damages to give them their office back? Next, these other mandatory obligations are inconsistent with the other findings. Reinstating and bringing them back on their computer systems, these are contract disputes. And so for all these reasons, they're not balancing the equities here. And public interest has an interest in ensuring the government is acting constitutionally. We also have an interest in making sure judges are only wielding their power when they're authorized to do so. They are only allowed to decide actual cases and controversies, not political disputes. Actual injuries to actual parties, not people who are suffering emotional damage and suing under pseudonyms. In sum, Trump has made the requisite showing that they're going to win and that they're going to be irreparably injured. And so for these reasons, we grant Trump's motion to stay the preliminary injunction pending appeal, signed by the Fourth Circuit Court of Appeals. And that will be a big victory that will, I think, be persuasive for, of course, all of the other courts underneath the Fourth Circuit. And this one originated out of Maryland, but also it will be persuasive for other districts. They'll say, Fourth Circuit is saying Trump has the power, Elon has the power, all this is operating perfectly. So Judge Chuang, I believe, who issued the one out of Maryland, and others are going to start to get the memo. So nice victory there for Elon and DOGE. And the cuts will continue, and the Court of Appeals in various circuits will start to settle these things out. And it's good news. We'll be here covering it accordingly.